Afrocestor. Learn, unlearn, relearn, repeat.
Nigeria is playing Cameroon today, and I hope that we win. We love our Cameroonian brothers, but then, we hope that Nigeria will win this. So, one very powerful quote about human rights is from Kenya. And this is from Kenya's first president, Jomo Kenyatta. And he said something very important and something I would love to quote him on. And he said, "Our children may learn about heroes of the past. Our task is to make sure that we are ourselves architects of the future." This quote encapsulates the essence of human rights advocacy, emphasizing more on the responsibility to create a better future by championing the rights and freedoms of all individuals. This is Afrocestor, and this is where we learn, this is where we unlearn, this is where we relearn, and this is where we repeat that process all over again for our own growth and prosperity as Black people. My name is Amari, and I'm here today with Nike in the house, and we are going to co-host this wonderful conversation with a wonderful guest. Nike, how are you doing?
Very well, thank you.
We've been looking forward to, discussing this with our guest.
Yeah.
And we're very happy that he's here for us to spur that conversation. So speaking of conversations, we will be discussing human rights issues and termination of employment with no other person but the distinguished and prolific Canadian lawyer by name Charles Osuji. His law firm, Osuji and Smith, which he is the CEO and managing partner, won in 2021 three best rated employment lawyers in Calgary. He has won it in 2017. In fact, it has become his birthright self. He has won it in 2017, won it in 2018, won it in 2019, and won it as well in 2020. So his law firm again won the 2021 three best rated business lawyers in Calgary for 2021, and was the third win, having won it in 2019 and 2020. Again, I can keep going on and on. This law firm as well has also won the three best rated divorce, civil litigation, and estate planning lawyers in Calgary. They have also won the 2021 Top Choice Award for Business Services in Calgary and the Hope Awards, and the Aspen Awards as well, among other awards. Again, his name is Charles Osuji. He's the CEO and managing partner of the Osuji and Smith Lawyers. Charles, we're very much happy to have you today. Reading all of those achievements is something that I'm so happy reading them. I did mention to you that the very first time I saw your name was someone picked me up from the airport, because I think backstage we are talking about my Toronto experience. Right. Yeah. Calgary experience was different. When I came to Calgary, I made friends already. Right. All thanks to Regina and Efe. They came to the airport to pick me. They even got me a house before I came and all of that. But driving me to my interview, which I had the same day I landed in Calgary, I saw Osuji and Smith in downtown, the banner, those small banners you put in between. And I was so happy to see Osuji, because definitely seeing Osuji, you already know he's an African and you know where he comes from, the root where he comes from. And I was so happy that in my head, I was making pictures of this Osuji as an elderly person who have been in Canada for
that all the time.
Yeah.
You get since the 80s.
Like when I walked in, I was like, okay.
Yeah. Wow. I was making that. I was like, oh, maybe. I was making a lot of pictures. Maybe his trip has been here for a long time to even, have. I don't want to say the audacity or the temerity to put his sign there. You get what I mean?
Yeah.
So, but that's some of the things we are going to discuss today. So when Charles, for our viewers, when Charles Osuji immigrated to Calgary from Nigeria, it was in 2011, he couldn't have guessed that a mere 5 years later, he would own a successful law firm. In fact, when the opportunity came for him to buy the firm, where he began his career as an articling student, he wasn't even interested. To him, it was a very risky move. But he has one thing we've been discussing. We talked about that in emotional intelligence. He had mentors who spurred him on, who kept telling him to take that leap. He said, and I quote, "I have a strong support system, so I took that jump. I was scared I wouldn't make payroll, but the path of success requires taking risk. And in less than 4 years since he took sole ownership of Osuji's firm, Osuji and Smith firm, which is unspecialized, has increased his earnings fivefold and is consistently a top-rated firm in Calgary. So please, I have one question to ask you. Do you think, can you allude your success in your firm in being unspecialized? You know, some people will be like, oh, I'm a real estate lawyer, a divorce lawyer, into certain litigation issues. Did the success from what we read here, did it come from more of you being unspecialized?
That's a very good question. And by the way, thank you,
Yeah.
Andrea. And
Yeah,
Nikki,
you're
for
welcome.
having me here. When I started my journey, when I joined Mr. Smith, my former partner,
Yeah.
he was a sole practitioner. He was just by himself and focusing on real estate. I knew right away, though, that for me to grow the firm, for me to have what I have today, would have to dabble into other practice areas. So that was how I introduced other practice areas into the practice, employment, business, divorce, personal injury, and all that. Now, 5 years later, what I'm planning to do is to have pockets of specialty in the firm. So we grew from 2 or 3 lawyers in the last 5 years to about 25 lawyers now in the firm. And there are different departments in the firm. So there's now a department for real estate, there's a department for personal injury, there's a department for divorce. I recently acquired an immigration firm of 5 lawyers.
Wow.
And they've been manning the immigration practice. So the plan is to have to run a full service law firm with pockets of specialty. So that if anybody walks into the door, regardless of what their issues are, someone will take care of them.
There's a service for them. Yeah. So amazingly, Nike, I know you have questions. Nike, I'm lost. Maybe I don't know. Should I say I'm starstruck? But then I know that what happened to you last podcast when we had the police here. When you're like, are you sure I'm sitting very good? Maybe that's the same thing that is happening to me because I've heard a lot about him.
Yeah.
His prowess, especially when it comes to his practice as well.
Yeah.
Yeah. I know you have questions for him.
Yes, I actually do. And like you said, I'm super excited to be here and having this discussion with you today. Just like we mentioned, like when I was hearing the name Charles Osuji, like I thought it was like mighty, like maybe I was going to see someone with gray hairs all over the place. So when I just come, I'm like, wow, this is actually big. Like this person sitting down here has this big name, which is really good. And I'm super proud of you and super excited to have you here also. Well, let me just dive right into the question I have. How can employers ensure fair treatment and avoid discriminations when an employee resigns due to like hostile work environment?
Thank you. Just to give the viewers and listeners some context, in as much as we run a general practice law firm, my specialty is actually employment law. Because I noticed very quickly the information gap that exists in employment law, especially with respect to people who look like us. And the dynamics when it comes to employment law from back home is very different from here.
Yes.
Many people shy away from asserting themselves as employees because of the dynamics that play at home. Back home, the employer is the master. Right? But here, in as much as that dynamics is still there, but there's several laws that have been put in place to mitigate against the imbalance of power between an employer and employee. So to your question, if an employee voluntarily resigns, and I'm going to be bringing these questions in the context of my practice as an employer. If an employee voluntarily resigns, first of all, I would make sure that I conduct an exit interview with that employee to make sure that the employee's resignation is actually voluntary. Because there's been situations where an employee has been subjected to workplace harassment, violence, toxicity, but they just couldn't speak up because of fear of retaliation. And they just put in a resignation. So it's important to have an exit interview create a safe environment for that conversation to happen, and find out what truly happened. And if maybe the employee found something better in terms of money, that's okay. But if there's something more systemic that is happening in my firm, I will use that opportunity to explore that. Secondly, even in a situation where an employee voluntarily resigns, the employer should not act in a retaliatory manner against that employee. In other words, how dare you resign? How dare you walk away? There's so many things the employee is still entitled to. For instance, the employee is entitled to their last pay. Sometimes the employee would give the employer 2 weeks resignation notice. If the employer is not comfortable allowing the employee to remain for 2 weeks, the employer should pay them out for the balance of the 2 weeks and not just kick them out. Right? So it's important that the employer complies with minimum requirements at the point of voluntary resignation.
Amazing. That's an amazing question, because again, when you speak about this, you mentioned something that struck me very well. And that is, you mentioned something about employers being the master, especially from where we are coming from. That scenario is still playing out here.
Yes.
And unfortunately, it's playing out amongst Black employers. When we wanted to ask some of these questions, it was employee. And I said, no. Does it mean that we don't have Black employers?
Exactly.
We do. That's why the next question I want to ask you right now is kind of not really scripted that much. But I can tell you that I've heard since we started this podcast, very toxic remarks about some employers. I'm not going to mention them. However, can you provide examples of how employers, I'm talking about Black employers now, because our podcast the motto of our podcast is learn, unlearn, relearn, and repeat. So there are things we need to learn and unlearn as well. That toxicity as employers, we need to start unlearning it if you're a Black employer. So my question is, can you provide examples of how employers can navigate termination scenarios? I know you mentioned something about having that exiting interview. This is the first time I'm hearing that, but it makes sense.
Absolutely.
It makes a lot of sense. So how can they navigate termination scenarios to avoid raising inferences of discrimination based on factors like ableism, gender, or even pregnancy?
Absolutely. It's very important that if an employee is terminating for cause, the termination for cause is when an employee has done something wrong that has led to a complete breakdown of the employer-employee relationship. In the context of a termination for cause, the employer should ensure that there's a termination letter, a written termination letter. You cannot just call an employee over the phone and say, by the way, you're not coming back to work.
You're fired.
You're fired. That happens on TV.
You
have to put the termination in writing. Communicate the termination to the employee and let the employee know why they're being terminated. Give them reasons why they're being terminated. And if the reason includes incompetency, dishonest, or whatever, what have you, the employer should have policies in place that provide the employee with clear roadmap to success. What are the do's? What are the don'ts? What actions are tolerated? What actions are not tolerated? So an employer should have policies in place. That policy should also have a progressive discipline mechanism. So if an employee commits tardiness, doesn't show up at work on time, that shouldn't entitle the employee to terminate right away. The employee should be given maybe verbal warning, after verbal warning, written warning, after written warning, maybe suspension, after suspension, then termination. So there should be a progressive discipline entrenched in the policy. So the termination for cause should meet those policies. If an employee is being terminated for cause, the employer has a duty to investigate. I've had thousands of clients who were terminated for doing something terrible, and there was no investigation. Or there was an investigation, but the employee was not involved in the investigation. The employee is a star witness in that investigation, that situation, but the employee doesn't even know. So there should be transparency in terms of the process of termination, there should be policies in place to determine what is wrong, what is right, so that when you punish an employee for doing what is wrong, you can cite a policy. And then at the point of termination itself, if the termination is without cause, in other words, the employee hasn't done anything wrong, but either because you don't have the money to pay anymore, or you're downsizing or you're restructuring, you have to let the employee understand why that is happening. Many people come to lawyers because they don't have closure, why they've lost their job. They simply get a letter that simply says, you've been terminated without cause, and that's it. Employees need closure. Employment means a lot to so many people. We spend a third of our lives working. So it's very important for transparency to happen.
But when there's no transparency, thank you for that. When there's no transparency, like you said, what are the compensations? When they come to you, what are the compensations that they could get, for our viewers? Because some people will be like, after that, then what happens? I just go to a lawyer. You know what most of us don't like getting lawyers involved, and also the police. It's part of why we are having this. Yeah, and this particular podcast episode will air right after the police, so that, because there's a way we want to position these things. There are some things that people don't like. Sometimes you tell someone, get a lawyer, and they're like, I don't want trouble. It's not trouble, but you're just protecting yourself and also your right as well. So what are those compensations that someone can get? Because I believe there's someone listening to us now that who might even want to say, oh, what they're saying, it touches me. It affects me. I need to get in touch with them.
I agree with you. I really, really love the motto, the mantra of your show. We learn, unlearn, and all of that. One of the things we need to unlearn is relationship with professionals who provide intangible services. Lawyers do not provide products, tangible products. They provide intangible products. Just like therapists, right? Where we're coming from, we do not pay we don't value intangible services.
Yeah, that's true.
Why would I pay a therapist $300 an hour just to listen to me? Why would I pay a lawyer $500 an hour just to hear me out? And then we have the perspective we have about lawyers is, oh, don't go to a lawyer. You're causing a fight. The reality is there are rules, regulations, and laws here. And everybody is subject to those laws. There's equality before the law. If an employee has been terminated, they have an obligation to go to a lawyer to make sure that their deserving compensation has been paid to them. The reality too is, if an employee is terminated for cause, for reasons that do not meet certain standards, the employee has the right to sue the employer. But before you sue the employer, the lawyer will help you negotiate with the employer. And negotiation is a right an employee has. I've helped thousands of people. I remember a client came to me thinking that they're only entitled to, I think, was it $5,000 after working for about 10 years. And at the end of the relationship, I got the client over $200,000 simply because they reached out to a lawyer who reviewed the manner of their termination and realized that so many employment laws have been breached. And it helps too to get closure. Sometimes the offer made by the employer is reasonable, but you need a lawyer, an experienced lawyer, to look at it and say, that makes sense. That way you're not looking over your shoulder, hoping or thinking, maybe if I had gone to a lawyer, maybe I would have gotten more. So the role a lawyer plays, especially in the employment context, is very, very important.
Now, having said this, and before Nike will ask the question, I will have to say to our guests that from where we are coming from is part of what we are saying on learning. From where we are coming from in Africa, almost every part of Africa, right? You get a lawyer when you're in trouble. Here, the truth is, just like Charles has said, you get a lawyer not to get in trouble.
Exactly.
So it's always a mix of both, but then it's always on the other side of it. And while we're just talking about employment, we're talking about other things that also need lawyers much more later. We've had Daniel come in here. Watch that episode where we're talking about real estate, Arinze Zonyeka, Richard Amatoku. All of these guys are talking. One of the things they keep mentioning is the fact that you need a lawyer, you need a professional in all of this. So please watch those episodes and also learn to pay, or at least get the services for intangible, get the services of professionals for intangible services as well.
Yeah, I'm sorry. Just to take us back a bit, like based out of what you were saying earlier on, like when you mentioned about verbal warning, right? Do you mean like verbally vented, or is it something that is being written? Like in a case of court now, like wouldn't it be like the employers or the employees wall against the employer if this is just being verbally vented?
That's a very good question. As part of the progressive disciplinary mechanism, sometimes a verbal warning is needed and doesn't need to be in writing. For instance, I recently hired a paralegal who constantly came to work late, few minutes late. You know, on my way to my office, I was like, "Hey, guy, try to be early next time and reach out to my executive assistant if you're running late." That kind of conversation doesn't necessarily need to be in writing. I'm giving them the benefit of the doubt. Don't do it again. But if that continues, then I put them in my office, have another warning, put it in writing, and let them know the consequence if they do not comply.
Yeah, you know why I'm smiling. Okay, I'll have to devote this. So when I came to Canada first, I don't look at emails.
Right.
Email is an integral part of working here. But coming from Nigeria and that work system, I wasn't always looking at my emails. That's number one. Number two was this verbal warning, just like you said, just on the way, I didn't take it seriously.
Right.
Then I was working in Brampton from Mississauga. I wake up by after 3 in the morning, around 3:30 or 3:40 something. And I still go late 5 minutes because from Mississauga to Brampton takes me about 3 hours of bus. I wasn't driving then. And I'm always 5 minutes late. And I couldn't understand when each time they came and they told me that try to be on time. It's not like I'm warning you now, be on time. Next time you will get into trouble. No, they just told me in passing. So I was thinking, don't they understand that I was expecting them to understand with me that I'm really trying, right? And until they pulled me in and told me that they've actually warned me 3 times, they said. And that's when I knew. And they gave me something to sign that, that was the written warning you are talking about.
Yes.
The next day, nobody told me to take a $70. I took a $70 Uber from Mississauga to Hamilton to get my car, my first car. Then I drove it. That day I came early and everybody was like, so what you just said is nice that Nike, you asked that question as well, because most people, when you see those warnings are not just, they're serious warnings actually.
Yes.
Yeah.
And they should be able to warn you. They should be able to put something in you that, okay, you don't want a situation whereby they drag you into the office because it's a very uncanny, nobody likes that experience.
Right.
Yeah. So before we continue, let's pay our respects to the indigenous nations on whose traditional lands we gather. These territories hold centuries of history, centuries of gatherings and celebrations. And we're very much grateful for the opportunity to live here, to end here, to grow here as Black people. And additionally, again, we honor and pray for our African ancestors who themselves were true leaders and whose resilience shaped our world. Mama Africa remains the birthplace of humanity, the cradle of humankind, and where we draw our strength, wisdom, and understanding, and as well as our knowledge. So we have the Nigerian Cameroonian match going on now. So I wouldn't want us to spend much time here so that we can also enjoy and be patriotic as well. So I want to ask this question, and how can employers, because my own is I'm just focused on employers because I know there are bad employers, and there are bad Black employers. There are amazing Black employers as well.
Right.
How can employers structure voluntary retirement programs to encourage voluntary exits? You mentioned some things that when you, in that interview, you try to know if the person is willingly, leaving, or if it's something is a systemic issue that doesn't allow the person grow or even have a peace of mind. So, but this time around, talking about voluntary retirements, how can employers now structure that into their plans to help, especially BIPOC, Black Indigenous people of color as well?
Absolutely. Just for context, voluntary resignation or exit is an option open to an employer who's looking to restructure, rather than arbitrarily determining who gets terminated and who doesn't get terminated. they can provide that as an option for the employees. One of the expectations on the part of the employer would be transparency as to the criteria for who gets the option, right? Who is getting this option? Are they certain professionals, or are there folks who have spent X number of years in the employment? So it's very important to ensure that the objectives or that the objective criteria are transparent. It's also very important to give the employee an opportunity to obtain independent legal advice before making a choice to voluntarily exit. When a voluntary exit is provided, some employees actually think that they don't have a choice but to accept it. Employers should endeavor to give the employees an opportunity to go seek legal advice. They go to a lawyer. Sometimes I even encourage employers to pay for the consultation. They go to a lawyer, review the exit, and the lawyer determines whether they truly want it. And that would foster voluntariness, so to speak.
Very good. Nikki, do you have further questions, or should I keep hammering the questions?
I mean, I think I can go ahead with one of the questions I have here. Sorry, okay. So in a company's, okay, let me just take that again. In company restructuring and layoffs, how can employers conduct fair layoffs without singling out individuals based on age, gender, or race to prevent potential human rights claims?
Now, to give context, a layoff is termination without cause, meaning that employee has decided to terminate an employee for no reason, right? And when we say no reason, we're talking about not legal reason, right? The employer is not terminating because the person is black, because of their gender, because of where they come from. People confuse layoff with termination. Technically, layoff is short-term layoff, like what happened during COVID. When employers cannot afford to keep employees on their payroll, they lay them off for 60 days. But I think in this context, a layoff, the question actually refers to a termination by the employer. Transparency is very, very important. 99% of the cases that come to me because the employers were not transparent in their decision to terminate, right? If an employer is transparent in terms of why they are terminated, it could be business restructuring, it could be making the position redundant, or whatever it is, or being honest at the very least as to why they're terminated. The role of a lawyer will be significantly reduced. I've had clients who were terminated because their position had become redundant. The following day, that same position was posted for others to apply. I've had employees who came to me because they were terminated and they were told that their termination was based on certain allegations or complaints made against them, but they were not given an opportunity to respond to those complaints. They were not part of the investigation. They were not given a chance to speak out for themselves. Lack of transparency drives an employee to the arms of a lawyer because the employee is looking for redress. They feel very hurt. They feel, especially people that have given so much to the employer year after year, and having the relationship come to an end in such a manner is always very, very disruptive and troubling. So transparency is very, very important. And fairness in the termination package is also very, very important. An employee who has spent 10, 15 years of employment with an employer should receive better severance than someone that spent a year. Regardless of what they look like, regardless of what they sound like. So fairness is very, very important. When I see a termination package that is fair, I immediately tell the client. Challenges this in court is going to be a waste of your money, a waste of your time as well. Accept it. So employers shouldn't cut corners in providing fair termination packages to employees. What is fair depends on so many factors. The number one factor is what is in the employment contract. Many people get excited when they receive employment offers. They don't look at the fine lines. Look at what happens if you're terminated. if you are if new employee and you receive an employment offer,
look
at the termination provision and see what you get upon termination. It could be a week per year of service, could be 2 weeks per year, it could be 1 month per year. If it's silent, it's a good thing actually, because you could get more in court. More would depend on the age of the employee, how long they've worked for the employer, their qualifications, how quickly can they find alternative employment, and how much they were making. Right? If it's someone in their 50s or 40s or late or 60s, they've worked for about 10 years in a management capacity, they'll be getting about a month per year of service. Right? So the compensation must be fair as a way of mitigating against litigation.
This is nice. I feel like since we are three of us, I feel like we should even. Is it Peter? It's Peter that did that thing in the Bible, right. Transfiguration. That we should have 3 tents. For me, I want you to stay here all along, but we have to really call it, close a curtain on this. Right. But however, before we do that, I would love to ask you 2 questions. One is, what is constructive dismissal?
Yes.
Then the second one is, what is this initiative called Foot in the Door Initiative, and how can people benefit from that as well?
Right. Yeah. Constructive dismissal is when an employer shows an intention not to continue the employment relationship without really saying it.
Okay.
Right? Employment can come to an end constructively, or it can come to an end by way of a letter. If you receive a letter of employment, nobody's in doubt that the termination has happened. But an employer can take certain steps or certain decisions that indicate to the employee that the employee is no longer interested in the employment relationship. For instance, if I hire an employee and I pay them $150,000 a year as a salary, and then all of a sudden, come February 1st, I say, look, I'm going to cut your salary by 25% without the employee's consent. That is constructive dismissal. Because what I'm doing at that point is telling the employee, I no longer want to honor the terms of our relationship. It could be a situation where an employer allows a toxic work environment to continue to affect an employee. An employee has come to the employer to complain about a certain individual. The employer has done nothing about it. This employee continues to feel targeted, marginalized, and abused at work. With that continuing to happen, the employee could actually claim constructive dismissal because the employer has allowed that pattern of abuse and toxicity.
It's more like a bullying or
to continue. So in essence, constructive dismissal is where changes have happened to an employee's employment, or an employer has allowed some abuse to continue without those changes being addressed.
Okay. Thank you so much. And the second question is Foot in the Door.
My Foot in the Door initiative. Before this podcast, you were telling me about your personal story. Some of the decisions we make come from our personal journeys. Right? When I came to this country, I didn't have any professional network. Young, imposter syndrome, lack of confidence. I didn't know if Canada would accept me. I didn't know if I would make progress based on the way I sound, the way I look. I applied to several places for employment, for articles, internship for lawyers. Nobody would call me back, including applying for volunteer positions. Nobody would call me back until I got one interview. By the way, I only had one interview in my professional life.
That's amazing.
One interview, and that was the interview by my former partner, Mr. Smith. And I got in, and I quickly realized that if I succeeded in my journey, I would make sure that I keep the door open for others coming after me. And that's how we grew as a community. And that was the reason why I started the Foot in the Door initiative. What it does is to empower internationally trained lawyers with Canadian experience. We've helped over 250 lawyers in the last 2 years. Currently, we have over maybe 50 in the firm. They come on a rotational basis. They come to the firm, they join the lawyers on consult, they go to court, they do research. They do everything a lawyer would do with supervision. This bolsters their confidence, gives them access to professional network, and makes them feel that they belong, that their experience matters. The objective is to provide people with the Canadian context, give people with the Canadian experience, and allows their journey to be smoother.
Thank you so much, because we've had that problem as a community where when we pass a bridge, we throw dynamite to it so that nobody else passes. But then this new generation, there is an awareness happening within the Black community now. Our generation, our young generation, they're changing a lot of narratives and a whole lot of things. So engage with us on our social media platforms. WMLG is a non-profit foundation, and Afrocester as well as the African. African means Africans living in Canada. And the initiative is to empower Africans, support our podcast. Visit our website at www.wmlg.net. I keep making this mistake. Yeah, it's www.wmlg.net. And WMLG means is a question, it's a rhetorical question asking what makes life good, right? All revenue goes back to our non-profit programs and initiatives as well. So usually when we want to round up, we have a conclusion. In concluding this, we hope this is not the only time we're going to see you. We understand your schedule is kind of very tight. We'll try to work with you so that you come back again. There's a lot of things we can do within this space to raise that awareness, that literacy angle of things. What would be your parting words to our viewers?
In terms of the conversation we've been having, pay attention to professional help. Gone are the days of self-help. Even when I took over the firm from Mr. Smith, I got a lawyer to review the paperwork to make sure that I was on the right path. We have to be conscious of seeking professional help before we make a decision. Not seeking professional help when things have gone south. So it's very, very important in the employment context. Generally too. And I also want to congratulate you guys for what you're doing.
Thank you. So
giving people like me a platform to talk about our journey and also provide some professional advice and opinion on certain core areas of expertise. You have no idea who's listening, have no idea whose life is being touched. So congratulations to both of you.
Oh, thank you so much. Yeah. Please, his contacts will be on the screen. His website as well will be there. I get in touch with him just like you said, just like we've been discussing here. So this is where we're going to give honor and respect to our ancestors, because we are Afrocester, African ancestors. We hereby honor and revere our ancestors, seeking their guidance to understand the creative intelligence and the life force within us. We can't thank you enough, Charles, for making this. It's not easy. Calgary, Canada is cold, but the Calgary cold is way different. And it's something that there's a usual saying that people who come here, taught us that if you don't like the weather here in Calgary, just wait 5 minutes, because it keeps changing, right? So thank you so much for coming here. We want to thank our production crew as well. We have Imo. We have our co-host here, Nike. Nike, thank you so much for being here. We have Mimi, we have Queen, we have Olumide. And I want to say a very big thank you to everyone, especially our viewers. We are nothing without you guys. My name is Andre Amari, and I'm saying the same thing all over again, which is stay safe, stay fit, and stay African. Ubuntu.